before me, sorry, and that is, milady, if I could ask you to go to the notice of application to amend at section 44.
Yes, and the page number?
Two, I apologize. Page 2, milady, at paragraph, the new paragraph 2.
Please repeat the ref page number.
It's section 44, page 2, milady.
Yes.
Then, milady, my instructions, as I understand them, are that so what this represents is essentially our prayer 2 in our notice of motion. It's just been tweaked, if I could put it that way, to make something clear. And we would, in the second line, not move for the words "and the Glenister Section 24A appeal." So when your ladyship compares that to our notice of, in fact, my lady, allow me just to consider what I'm actually being instructed here, my lady. My lady, so there, I forgot at the outset just to make mention of something to your ladyship. Forgive me. There was a bigger team in this matter. You would have noted from the practice notes that advocates Pierre Duval, SC, and Andrew Duminy were also in the team. And of course, we have worked on different things at different times. Advocate Duval asked me to tender his apologies for not having been able to alert you to the fact that he wouldn't be in the matter anymore. But when His Lordship, Deputy Judge President Ledwaba allocated dates, we had to take what we could and hope we could sort it out, and both him and Mr. Duminy had to fall out of the matter. But I just want to test, because they were responsible for this aspect, and I just want to test myself. So, my lady, what I've done is I've taken out the notice of motion for your ladyship's notes. That's at 003-2. And I just want to confirm what the difference is here. So what we've changed, my lady, and allow me to read paragraph 2, or prayer 2 of the notice of motion reads that pending the finalization of the second applicant's appeal and any legal processes pursuant thereto, including any review application and appeals against the decision of the third respondent to authorize the product. We don't say how it's authorized, whether it's one section or another, for use and or administration in children aged 12 to 17 years of age. The first and second respondents are interdicted and restrained. What we do in the amendment, my lady, is we say that pending the finalization of the second applicant's 2 Section 24A appeals. Now, if the contention is made that we're expanding our cause of action, we're not, my lady. Our cause of action is an interdict hinging on the rights of children, represented here by these applicants on their behalf. That's the right. We don't even say it's prima facie, it's a right, my lady, actually. Given the irreparable harm we describe in all of the evidence, and where we criticize the deficiency in Cyprus papers in particular to put up any evidence, hinging, of course, milady, in and around the various arguments that go together.
Can you get back to what you want to change in paragraph 2?
Well, milady, I'm dealing with the fact that they argue that this is a change of the cause of action, and I accept that your ladyship knows where I'm going. There's no change of cause of action.
So you're not asking for any amendment in the amendment. You're going to ask for the amendment as it is.
No, my lady. I've said to your ladyship in the second line that we're going to remove the words "and the Glenister Section 24A appeal." But I'm trying to point out to your ladyship that there are other slight changes in here, and I'm trying to be full and frank with your ladyship. Yes. So, my lady, what we change it to is both of our appeals, our Section 21 and our Section 15. It's no change of cause of action. The cause of action is the same. And that's what we seek there, my lady. And then I just want to see if there's anything else I might pursuant there too, including against the decisions of the third. It looks like it's the same for the rest, my lady. And if there was anything there that wasn't necessary, we would gladly surrender that too. What we want to reflect in our amendment, my lady, is that it must be clear that our cause of action achieves its objective, which is to stop the rollout of vaccination to children on the whole. If parents take their children and they get a script from the doctor and it's done, of course, we don't have a problem with that. We don't impugn the 20 Section 21 authorization to that extent. We impugn this bolus rollout. It's all safe, all come and have a vaccine when there's no informed consent to make a decision as to whether one should or shouldn't take it, especially in relation to children who from the age, I think it's Section 25 of the 28 of the Children's Act, can opt for this without their parents' consent. So, my lady, there's no change in the cause of action. We take out the words and the Glenister Section 24A appeal, but we submit that the inclusion of both of our Section 24A appeals, all it does is that it makes clear what our cause of action is and how the facts have developed, my lady, and in order that your ladyship would grant, if you were with the applicants, would be clear and unequivocal and useful in the public domain, my lady, and not to give rise to further unnecessary litigation. So, my lady, on the context within which you received our applications and the respondents received our applications this morning, my explanation on how the joint affidavit came about and its importance and relevance, and why we say, my lady, that these applications are important, because what they do is place before your ladyship evidence from which your ladyship can conclude that the respondents cannot succeed against the case put up by the applicants. Lady, I'm not going to deal with costs. We've asked in these applications costs have opposed. I don't know where it's going to go. I'll hear the submissions of my learned friends. It may be that these costs belong properly in the cause ultimately, my lady. But I'll hear what they say and deal with that in reply. We thank you, ladyship, for your patience.
Thank you, Mr. Wallace. Mr. Rowe? Mr. Crompton? Yes.
Yes, my lady. I just want to confirm that the third and fourth applicants, we associate with the various relief that the first and second applicants seek in the interlocutory matters. We also associate ourselves with the submissions, comprehensive submissions made by Mr. Willis. There's just one very brief point I wish to make to your ladyship, and it goes to the relevance of the conduct of SAPRA and their failure to file a record in those appeals. My lady, this case is subsidiary to the appeal. In other words, your ladyship has to make a decision whether there's reasonable prospect specifically the second applicant in the appeal. I would submit that the information we've put before you through the rejoinder and supplementary affidavit go to the very heart of the prospect of success. They are highly relevant to the eventual decision that your ladyship should make. I think that the conduct of SAPRA and especially the affidavit that was filed this morning go to the very heart of the prospects of success, and we seek from your ladyship the inference that we have reasonable prospects of success.
Thank you very much, Mr. Crompton. Mr. Royal?
My lady, I would submit this is a case where allegations of vexatiousness, which are entirely specious, demonstrate to be charitable, my lady, the misguided approach. But I would, if I were not being charitable, I would say to bring allegations of vexatiousness in regard to a valid objection as to process. We don't even need the word valid objection, a reasonable objection as to process, and to seek to then go into the merits of the matter, to accuse all three of the respondents and it's in respect of the first and second respondents, because we are said to have aligned ourselves with this vexatious strategy. Milady, when the respondents, all the first and second respondents are doing, I don't speak for the third respondent, is executing their executive responsibility, is with respect, my lady, to go from arguing a matter dispassionately to arguing a matter passionately. And I approach. The first flaw is this, my lady. A party who seeks the admission of a further affidavit seeks an indulgence from the court. The usual rule is 3 sets of affidavits. This is trite. There's the 4th affidavit in this matter, which approach. The first flaw is this, my lady. A party who seeks the admission of a further affidavit seeks an indulgence from the court. The usual rule is 3 sets of affidavits. This is trite. There's the 4th affidavit in this matter, which a formal application for admission was made, to which there was no objection. My lady, strictly speaking, because it is hard to disentangle whether an affidavit is purely in response to a further affidavit, whether it is adding something new, clarity should have been sought by the applicants before they sought to file a 58-page or however many pages rejoinder. Because essentially all supplementary affidavit of SAPRA does is to say this: your application, which is replete with Section 21, has now been rendered moot because there is now a Section 15 approval. That's all it says. From that single fact, we're now in the Texas court. We're now in really very fiery allegations being directed at Pfizer. We are talking about an appeal record, a non-disclosure of the appeal record, and one just gets into this question: what does all this have to do with the matter? So that's the first misconception, that they could simply file this very lengthy rejoinder affidavit as of right. If they were entitled to file this very lengthy rejoinder affidavit as of right, I'm confused with respect. Why do we have an application for the admission of a supplementary affidavit, which basically refers back to the rejoinder affidavit? So that's the question as to the affidavit. The second point to make is this casting of false straw men as to our position. The lady, counsel for the applicant, says that we made an election not to file an affidavit or not to oppose the application for admission on the merits. Lady, we made no such election. We say that before we even get to the question of whether we are required to formally get into the procedure of opposing, one has to look at the form of what was before you. Third, it comes from the election point. Casting of a false argument in which I am purported to have said that our objection has got something to do with the fact that we weren't afforded 10 days as per the rule. I said nothing of the sort. Far from it, my lady. What I said is that we should have been given a reasonable opportunity in the notice to be able to object if we so desired. And I said further that if one looks to what happened after we in fact object, despite not being invited to do so, one can see the reason for it. Because we get an application after our objection for the admission of an affidavit, for the admission of an amendment, without giving us an opportunity to say anything about it. So not only is the notice of intention to amend give us no opportunity to object, the process which follows upon it gives no facility to the first and second respondents to say why we seek to object to the amendment, which is not just a question of pure law, because if it were a question of pure law, I'm at a loss as to why we have, for the last 2 hours, heard such impassioned argument. But it essentially revolves around this, my lady. One is, my learned friend can talk about there's actually no amendment because it's always there. But one doesn't just look at the notice of motion. One looks at the affidavit. The affidavit, the notice of motion is just, in fact, the prayers which are asked for. The affidavit constitutes the pleadings on the facts in support of the pleadings. The facts in support of those pleadings are anything to do with the experimental nature of the drug. The application is that, yes, this may be a licensed, approved product under the Medicines Control Act, But the decision now, which is not anything to deal with an interim stage of approval, which is a final approval, a licensed drug, is flawed. Now, that is a new case, milady, and we would have sought to have demonstrated that had we been given the opportunity to answer. Fourth point, milady, is the letter, which my learned friend has quoted from, is with respect quite topsy-turvy as to the facts. It's not for an applicant for a further affidavit to then come along and say to the other parties that if you should seek a postponement, you better tell us now, failing which our affidavit must be taken as accepted. We're not going to apply for a postponement. But lady, I thought it was trite. Party seeking an amendment or the admission of a further affidavit is seeking an indulgence from the court. We have the opposite. We are told that if we resist an amendment or an application, we are seeking an indulgence from the court. In fact, it's completely backwards. We have made no election, as alleged by my learned friend. We have simply said the procedure which you have adopted is with respect flawed, because it doesn't build in any opportunity other than to hear the sound of one hand clapping.
Thank you very much.
Yes. And then the final, just as my learned junior points out, the final point is I'm left with some confusion as to why our objection is redundant, because our objection as to procedure, our Rule 30 objection, is redundant because SAPRA has filed a substantive unconditional notice of objection under Rule 28.3. I just don't understand it. We
as you could hear from our questions to Mr. Willis, I also don't understand it, and I still don't understand it.
So
but perhaps in reply, you can try and address it again.
Yes, I'll be brief for one more minute, milady. Our position is the following, just so there is clarity. We say we're not even at the arguing of an amendment stage. It is the applicant which would be required to make an election, which it has not done. If it seeks to amend, and if it seeks to introduce a further affidavit on the very eve of, or the very morning of the hearing, it is seeking an indulgence, and it must apply for a postponement. So if your ladyship is not inclined, and I have hesitated even getting there, because really, my lady, we are faced with a COVID vaccine, and this lawfare is unseemly. The department needs finality on the matters and not to linger it. But if your ladyship would not be inclined to simply say that neither the supplementary affidavit nor the amendment before this court, and if your ladyship would be inclined to allow the matter to linger, if there is any postponement of the matter, it would be for the purposes of the applicants bringing a substantive interlocutory application. And in the circumstances of this sort of postponement, my lady, we would say that we are so far outside of the realms of Biowatch, with allegations of invective allegations of vexatiousness, which traverse the merits in a very unilateral, one-sided fashion, to justify the inclusion of documents where the reasonable approach would have been to say we seek the admission of affidavits and amendments which contain arguably new material, arguably a new cause of action. They don't have to concede either of those points. And in the circumstances, we ask that the matter be postponed. But if they don't say any of that, were the matter to be postponed, we would suggest not only should the applicants be required to pay costs, but they should do so on a punitive scale, including, in the instance of the minister, including the costs of 3 counsel. As your ladyship pleases.
Thank you very much.
As the court pleases, my lady. My lady, if I may begin with the the allegations of vexatiousness and delinquency that have been leveled against SAPRA. It's not the first time that the applicants have done it, my lady. It's conduct which they seem prone to. At this stage, all that remains for us to say is that these allegations are unfounded, they are spurious, but more importantly, my lady, they are designed to mask serious inadequacies in the applicant's case, nothing more than that. And regrettably, they're designed to mask mismanagement in the applicant's litigation. And I will demonstrate to your lady where that mismanagement lies. Lady, your ladyship correctly pointed out to my learned friend that when they brought this application, they brought it under Rule 612. But what that application did, what approaching this court under 612 did, is it triggered in 2 case management meetings before the DJP. And in both of these meetings, the first being in December 2021, and the second being in February of this year, my lady, a structured timetable was laid out for the parties. Now, all of us involved understood, my lady, that what that structured timetable required is it required compliance from every single one of us. And to the extent that any one of us were going to step outside of that structured timetable, we needed to get the leave of the court to do so, either in advance or afterwards through a condonation application. It's as simple as that. And that's a trite principle. So your ladyship, with great respect, was 100% correct when you put to my learned friend that 612 doesn't entitle my learned friend to do as he pleases for as long as this litigation subsists. What it did is it entitled him to get that initial meeting with the DJP to place this matter on the roll as a special allocation. But once the DJP had laid down that structured timetable, my learned friend, like the rest of us, was obliged to comply. Now, there was a disruption, and we accept that, my lady, of that structured timetable. And I'm going to take your ladyship to exactly where the disruption happens. And this disruption comes about on the 11th of March, my lady. It comes about when SAPRA brings a formal application for leave to introduce its
the rejoinder, my lady, comes in over a month in an urgent application.
035-6.
Over a month after SAPRA files its supplementary affidavit. It comes in over 2 months after they lodge their appeal.
Now, what this is, my lady, is this
absolutely no explanation for why there was radio silence from the dominant litigant.
That's where your ladyship sees the notice of motion, which has got annexure 8,
which they were well aware of.
And
then what you see happening, my lady, in this
supplementary affidavit, which SAPRA seeks
what they call a rejoinder.
Context, my lady, at this stage, there is a structured timetable in play. The parties have already filed heads of argument
that they put up
so
to deal with
those
well two incontrovertible facts and that I had taken your ladyship to.
It seeks to introduce 2 incontrovertible
no explanation by them as to why the affidavit is traversing way beyond the scope of the supplementary affidavit. Firstly, no application by them to the court to say new information has now come to light. We have to put new evidence before the court and asking and seeking the leave of the court to do that. Absolutely nothing. They put up, and you heard my learned friend say to you, my lady, they did it as of right. But any litigant looking at this document would know they simply had no right to do so. Even if it was the response to the supplementary affidavit, they would need to ask the leave from this court, and obviously none of us would have opposed it. But they go much further. They put up a ton of evidence and spurious allegations. We've described them as vexatious allegations designed to embarrass SAPRA, the regulator. They put that up without any explanation for why it's being handled in the manner that it is. So, my lady, in conducting our litigation, we're not in the business of throwing out allegations, but we say to your ladyship that the facts speak for themselves. It's very clear from what I've taken your ladyship through exactly where the fault lies in how things have transpired. The applicant then, rather than adopt a measured approach and say to the court, We're aware that our relief sought and our application is moot in light of the Section 15, but we would like to introduce the Section 15 in the current application. We want a postponement of this matter so that we can update our affidavits, we can amend our notice of motion, we can give the parties a proper opportunity to respond thereto, so that when the matter does come on the roll, the matter is properly ventilated on the papers and the parties are able to address the court on both the Section 21 and the Section 15. That's what a reasonable litigant would have done. Instead, my lady, they ambush all of us with a flurry of affidavits this morning as we're ready to appear before your ladyship. They insist that the fault lies with SAPRA. They throw out names. They call SAPRA all sorts of names, my lady. But they don't do what any normal litigant would have done and come to courts with clean hands saying, we know that there's a shortcoming on our papers. We want time to address that. Please give us the time and allow us to ensure the papers are in order. My lady, we say that, and your ladyship will recall, and I'm loath to mention what happened in chambers, but we insisted that they must make an election. That election was, do you argue on the papers as they are, or do you ask for a postponement in order to bring your papers in line with where you want to be? They've chosen not to do that, my lady. And we would submit the consequences of that is the following: that your ladyship is enjoined to dismiss all their papers filed after March 2022. And the simple basis on which that is done, my lady, is the applicant's absolute disregard for the rules of court, the applicant's absolute disregard for basic principles of fairness. And my learned friend throws around the Swifambu decision, my lady. He need not even have gone to Swifambu. It's a basic principle that we all well aware of. The rules are certainly for the court and not the court for the rules. But that doesn't mean he gets to do what he wants to do. Ultimately, the overriding principle, my lady, is the interest of justice, which must include fairness to all the litigants in the matter. And that fairness we would submit lay in the structured process which the DJP put in place. And to the extent that any of us stepped outside of that structured process, we needed to ask for leave. That's a basic principle, and your ladyship will know the absolute importance of that principle in these kinds of matters, where one is sitting with multiple parties and the opportunity for each one of them to derail the process if there aren't proper rules in place. So, my lady, my submission to your ladyship is the applicants have conducted themselves in a reckless manner. There's no other way to describe it, and I'm sorry to use the term. I do not do it easily, but it is nothing short of reckless. And regrettably, they must pay the consequences for their reckless conduct. And that means that everything gets dismissed, my lady. The matter must be argued on the papers as they stand. To the extent that your ladyship is inclined to give them a postponement in order to bring their papers up to speed, we would submit that that postponement cannot be on any other basis, but with full costs against them and costs on a punitive scale, simply in light of their reckless conduct. Apart from that,
there's no constitutional issues raised.
There are no constitutional issues, and BioWatch certainly does not cover this type of reckless conduct. Reckless and vexatious conduct, my lady, falls outside the BioWatch rule. So certainly the applicants would not be able to take cover under the BioWatch principle. And they were given ample opportunity to ensure that they conducted themselves in the appropriate manner. It was done all along. And certainly, like I said to your ladyship, had they just followed the rules, any of us would have been hard pressed to stop them. But they've not done that. They've chosen this bullish approach. They've chosen to do it in a way that brings embarrassment to the other parties, rather than us all working in one direction to try and ensure that the matter is properly placed before court and properly argued before court. My lady, in relation to the objection, your ladyship and my learned friend Mr. Rome covered the principle that the objection was brought in a way that really one cannot even begin to understand how it was considered appropriate. It was an annexure to an affidavit rather than a proper notice filed. It's correct that we filed an objection. We did it in order to get to the heart of the issues before your ladyship. That doesn't in any way undermine the Rule 30A filed by the minister. The bottom line is that the objection hasn't been met. The grounds of the objection hasn't been met. So quite simply, my lady, my learned friend has not come out of the starting blocks on the objection. And there's a price to be paid for disregarding the rules, regrettably, and this is the price. So, my lady, those are our submissions. I am not going to bore your ladyship with what's happening before the appeals committee, with the real nature of the mootness issue. I think it's quite clear to everyone involved. But certainly, at the appropriate moment, SAPRA will deal with all of the allegations that have been made that pertain to the appeal. But I don't intend to detain your ladyship with those at the moment.
Thank you very much, Councillor.
As the court pleases, my lady.
I'm assuming the amicus curiae is just watching and having coffee.
My lady, we are largely watching. I think, I'm not sure if this would be the appropriate time, but at some point, depending on the outcome of these applications, it certainly has implications for my client and cost implications for my client if there is to be any postponement. So whenever the appropriate time to deal with that issue is, we'll be ready to make submissions.
Okay, thank you. Mr. Rautenbach, are you still waiting to address me pertaining, you're still waiting to hear if there's going to be a postponement of the matter, is that correct?
Yes, my lady, that appears to be appropriate because it will cure much of the prejudice which the respondents understandably complain about. We don't want to stand in the way if that can be addressed in some fashion.
Thank you very much. Reply, thank you, Mr. Willis.
As a ladyship pleases, my lady. So I'll try and address it in the order in which it was put to you, my lady, and argued. Lady, bearing in mind, with respect, this is not a Thursday morning motion court matter. This matter has been specifically allocated. We've waited a long time for these dates. This contention that we were bound to a schedule of sorts by His Lordship, Mr. Justice, Deputy Judge President Ledwaba, is not correct, my lord, my lady. Simply because he regulated things up to a point, and then we were granted a date. It with respect, doesn't hold water, my lady. This matter, in fact, was initially agreed between the parties to go before 3 judges. We couldn't secure 3 judges and a date. We had to take what we got. This is a matter of significant importance, my lady. We have done everything to keep the matter on track. The big debate comes in around the rejoinder affidavit. Because if you find that the rejoinder affidavit is all relevant, and that SAPRA didn't put up all the relevant facts, they put up what they believed was relevant. But by putting up relevant development...
Can I just ask you this? Are you going to apply for a postponement, or are you going to fall by your argument?
Well,
stand or
lady, I don't have instructions to ask for a postponement. Your ladyship is going to find on these matters. If your ladyship's giving me an indication that you find no merit in that, then I must take that instruction.
Mr. Willis, you have filed serious supplementary and rejoinder and a notice of amendment just before the hearing and on the morning of the hearing. It's normal practice for you to then say, well, I need to give the other parties a fair hearing and a fair chance to answer to that. It was necessitated by certain documents coming to my attention, and that is why it's late, but I do accept that there must be fairness. And what I'm doing is I'm warning you that the argument on behalf of the respondents is correct. Either you ask for a postponement or you stand and fall by what you're arguing now.
Well, milady.
So I would suggest that you get instructions.
Well, milady, your ladyship has not heard me in reply firstly. I've not had that opportunity, but your lady has now told me what your view is. We don't agree that they were correct at all, milady.
Okay, I'm then listening.
We don't agree, but I will take an instruction. I'm going to have to ask that the matter stand down on instructions and take that instruction. But in the meantime, milady, I want to nonetheless make the following submissions to you. I want to correct a few things. Sorry, give me a second, milady. I just want to tell my attorney what I require him to do for me.
Certainly.
Lady, if you just give me a moment, I'm struggling to get my mouse to.
Certainly. In fact, can I ask if we can have just a 5-minute comfort break?
As your ladyship pleases. Thank you, milady.
Would you need longer, or is 5 minutes fine for you?
Lady, maybe, I don't know what telephone calls need to be made, maybe 10 minutes. And then
Okay.
I can.
Well, let's say we'll be back at 1:15. Mr. you want to say something?
Yes, my lady, we would need to take instructions on this issue. Could I ask that we be given till 1:30?
Yes, that's fine by me. The matter then stands down till 1:30. Thank you.
The court pleases.
counsel ready to proceed?
We're ready from the respondent side, Judge. The second and third respondent. I mean, sorry, the person second.
Third respondent is ready.
For the applicant, Mr. Willis.
Milady, we're just waiting for a final instruction. If I could just ask for just 2 minutes. We don't need to go offline. Just 2 minutes, Milady. Thank you.
Okay, I'll just take myself off camera. You can just give me an indication when you're ready.
Thank you, Milady. We're ready, Milady.
Thank you very much.
As a ladyship.
I'm listening, yes.
Thank you, Milady. Thank you. Thank you for the indulgence, and thank you for the view. We'd like to persuade your ladyship otherwise, but we have an instruction, Milady. The instruction is based on the fact that, Milady, this matter is of significant importance, and we have to make a decision that advances the cause of the matter. Milady, we have an instruction to seek a postponement. We would tender the costs, but we only tender them on the party-party scale, of course. If the respondents persist in wanting a punitive cost order, well, then we would submit your ladyship, or in those circumstances, to put it in reserve the costs. They can be dealt with later. And apart from that, Milady, I just wanted to make 1 or 2 submissions in relation to costs nonetheless. Before I do that, I just wanted to correct Mr. Rowe. We did not term the actions and decisions today to be vexatious. What we called vexatious was in particular the SAPRA conduct, which we've set out under affidavit in the papers. Today, we just say is inappropriate given the nature of this matter. Milady, in considering costs, Milady, nonetheless, this is the difficulty we had, is they've never put up what their prejudice truly is. And apart from the fact that we do the proper thing by tendering the costs, before your ladyship is inclined to exercise your discretion otherwise, notwithstanding my submission that if they want higher costs, they should then be reserved. Your ladyship has never been told actually what their prejudice actually is, and that would be a matter which would be debated at a later stage before the court finally hearing the matter once everything is then properly ripe, as no doubt your lady would like to have seen it. So, Milady, as far as the submissions on BioWatch go, Milady, this is a constitutional court matter, and my authority for that, Milady, and even the issues that arise here fall within that domain, and that is Harry Lull's case. Milady, you will find Harry Lull in our heads, and Harry Lull makes patently clear the extent to which BioWatch does apply. This is a PUDGA application. Effectively, Harry Lull specifically says a PUDGA application is a constitutional matter. And all of these factors here, Milady, are not simply procedural because...
Excuse me, are you saying this matter is a PUDGA matter?
The entire matter is... Ultimately, Milady, this matter falls under PUDGA when... Allow me just to explain this for what it's worth, Milady. You've got an administrative action and a party's entitlement to just administer and fair administrative action. That resorts under, that's constitutional, Milady. This is an internal remedy that has to be exhausted first. And after that, Milady, the remedy is obviously reviewed. When we say, Milady, this is a constitutional court matter, we say that these issues all feed into them. We say that, Milady, only insofar as your lady is pressed to grant an order outside of party order. Milady, so I repeat, Milady,
can you please mute your microphone? Not you, Mr. Willis, please, but the person talking. Yes, thank you.
So, Milady, to repeat, we accept your ladyship's view. We accept your ladyship's, the criticisms that your ladyship has been persuaded by. We would seek a postponement of the matter because that's the only proper result in the interest of justice.
Yes, it's not a satisfactory result because obviously I had to read these papers, make them my own. And in this division, it means that I had to do that over weekends, on the holiday, and at night times. So it's for nobody is this a good situation. And I cannot foresee that we can postpone it to a specific date because the intermediaries will first have to be dealt with.
So, my lady, can I say this, my lady? Your ladyship has read the papers. It may be so that the applicants held onto this date too dearly given the interest at stake. And obviously, once this matter is now postponed, my lady, if I'm allowed to be so presumptuous as that's what you're going to allow, then, my lady, of course, we would need another date. For this matter to be passed to another judge, my lady, would obviously, or to be a date to be found and a judge on the roster to be found, that might take longer than us prevailing on your ladyship to retain the matter, especially in that as much as your ladyship has done two things. You've sought to prepare on the matter and you've also sought to act in the interest of all the parties. So, my lady, we would, in that, I've taken the opportunity, my lady, just to prevail on you to maybe retain this matter and to assist the parties ultimately in bringing this matter to finality in the nearer future rather than the longer future.
Yes, we'll discuss that. Perhaps the other parties don't particularly want me to carry on with the matter, but we can discuss that later when I've made my decision whether there will be a postponement. Yes.
Yes, my lady. So, my lady, the interests of justice dictate this matter. If your ladyship doesn't postpone it, well, then your ladyship obviously would need to, one, hear me in reply, decide the matter, and then decide.
I'm not taking away your right to reply, Mr. Willis.
No, I appreciate it, but your ladyship is well within your rights to express your prima facie view, and a party must do what they best consider. So, my lady, I'm not. This is not, we haven't brought a substantive application. You've already heard that, and we haven't. But on the basis of your ladyship's indication, in the interest of justice, we seek that postponement to regularise the matter. We tender the wasted costs only on the party scale. And as I've said, if they want to contend for more, my lady, well, then we submit that the costs should be reserved because the issues are far more contentious, as your ladyship has noticed and heard. But we are asking for that indulgence. I've advised my client it is proper to tender the wasted costs on a party. Thank you, my lady.
Thank you. Pertaining to costs, can I then hear from Mr. Crompton? Yes.
My lady, I'm in a similar position as Mr. Willis. We seek a postponement. We tender wasted costs on the party and party basis. Those are instructions.
Thank you. Mr. Rowe?
Thank you, my lady. My lady, you've heard our submissions. We won't repeat them. We don't submit that it would be proper to say that if we persist in what we have sought as to costs, that ipso facto the costs must therefore be reserved. It's not on the basis of prejudice. My learned friend, Ms. Pillay, set out with respect correctly that it's really to mark the disapproval as to the reckless disregard of procedure and common reasonableness. As your ladyship pleases, you've heard our submissions as to why we would prefer the matter proceed, and I won't repeat them.
Thank you. Thank you, Ms. Pillay.
My lady, we have, like Mr. Rome, we also persist in our initial submissions. We submit to your ladyship that the conduct of the applicants cries out for a punitive cost order. So we do persist in seeking a punitive cost order.
Thank you very much, Mr. Berger.
My lady, I don't know if the tender would cover the amicus's costs as well. If it does, then we would be satisfied with that tender. If not, then the issue of costs should be dealt with in the main application.
Thank you. Mr. Willis, does that include the present admitted amicus costs?
No, Milady, it ordinarily doesn't, Mr. I forget Jonathan's surname, sorry. Mr. Berger's submission is corrected. That ought to be reserved. Milady, can I just respond? The allegations, or the argument that punitive costs are warranted are very, very fact-based. Your Ladyship ultimately is not going to make that determination. So we would submit to your Ladyship that the proper order is a cost order.
But the argument is the fact that it was brought today that from the 22nd till now, yes, they accept stuff had happened, which may have necessitated that you filed different things or whatever, but that you should have approached the court for condonation, or at least have filed an application for condonation.
Your Ladyship
for allowing the court to allow a further affidavit, or for the amendment to be properly heard.
No, Milady, your Ladyship
it's not based on any other facts. It's not based on the facts of the matter. Well,
Milady, they based on facts. Then your Ladyship needs to have regard, Milady, to our affidavit that put up the explanation. So I only took you through part of that, and that's today's affidavit for a supplementary affidavit. Your Ladyship informed me that you had read through the rejoinder affidavit. But to make that determination, Milady, you need to have specific regard in relation to the affidavit we filed today for supplement. Because therein, Milady, are the full facts which explain the Hobson's choice back on the rejoinder and the Hobson's choice here in the interests of a matter, Milady. If these litigants, applicants, were simply to take the view that, well, let this drag on and that's just how it is, Milady, it doesn't reflect the interests of the matter. And as we've always said, we appreciate they may want to reply, and hopefully they will in due course, Milady, but that doesn't fall to make our conduct reckless. We would ask you to please, Milady, before just making a decision here now, to then reserve your issue on costs. Please have regard to our affidavit filed this morning, which we've made submissions to you on, bearing in mind, Milady, that there's a far bigger factual matrix to this matter than what time has allowed us to actually submit to your Ladyship. Milady, it's not deprecating behaviour. Your Ladyship's got to properly contextualise the actions of the applicants. They were not malicious. They were done in order to do the best, see whether a matter could be retained on this roll and heard.
Let's for a moment say we accept that, but I mean, you had to be nudged to ask for a postponement.
Milady, you're right, Milady. The postponement of this matter is not ideal. But we've debated the various issues arising this morning, and your Ladyship has given us your prima facie view, and we've made an election. We've had to make an election on that, Milady. We don't accept the submissions that it was for us to ask for a postponement of a matter of this nature. Milady, this is an urgent application. Urgent matters come before a judge, and then the judge decides what will happen. It wasn't for the DJP to decide what's going to happen today. It was for your Ladyship to decide what must happen, and your Ladyship's given us that indication. So, Milady, this was not reckless. We're in an urgent application. I remind your Ladyship of Republicaanse, it's Republicaanse pers. It's very well used in your division as well.
Yes, exactly in that matter it says that right. The only thing that happens with an urgent matter is that the time periods are shortened, and the hearing right. And no time periods were given for the amendment. Well, there's no time for them today to answer to a supplementary affidavit.
Well, Milady, we could have arrived in this court on SAPRA's affidavit. We could have objected to it on the basis that it doesn't put up all the facts. We may have filed our own affidavit. Things could have been very different, Milady. These are fluid things, my lady, and the point is that on the proper test, my lady, in an urgent application, a court largely tends to accommodate an applicant in a matter of importance. That is stated many times over, my lady. And we would say to your ladyship that there were prospects that this court would entertain that approach today. There was no malice. We describe the conduct of another party on facts. We don't just say them out of the air, we put them in an affidavit. We're entitled to do that. But, my lady, there's no malice on the part of the applicants to derail this application. On the contrary, the applicants have done everything to keep this on track. And, you know, my lady, the bigger picture, my lady, is that if they want their punitive costs, they want it to be deprecated, well, that can happen in due course, my lady. That can happen after a fully fleshed out hearing in the matter by yourself or another judge, my lady, and then an appropriate cost order can then be made. But we've done what our clients have done, what we believe is the right thing, and tendered them on the party scale, my lady. We thank you for your ladyship's indulgence in time and listening to us. Thank you.
Thank you. I'll give my ruling at 14:30.
As your ladyship pleases. Thank you.
The court will adjourn till then.
I always had my nose in a book.
Is everybody on, Jonah?
Judge, it seems so.
Thank you very much. My ruling is as follows. The applicants in this matter brought an urgent application seeking an order that the Minister of the National Department of Health is interdicted from rolling out the Pfizer BioNTech COVID-19 vaccine to persons aged between 12 and 17 years, pending an internal appeal and ancillary relief of adequate publication of such order and the emergency use of an administration of the vaccine on a case-by-case basis to teenagers with comorbidities. The respondents opposed this application. Section 27 had been admitted as an amicus curiae. The organization Help South Africa also had an appearance today from counsel, but have not been admitted as such before the court. And my order is that they must be admitted. The application must be enrolled and heard before the finality, before this matter is heard. In other words, they must bring such application before this matter is finally heard. It is common cause that the third respondent sought permission to file a supplementary affidavit setting out new facts, and there was no objection to this affidavit that was filed. A rejoinder affidavit is then filed substantially later by the applicants, not limiting its answer to the incontrovertible facts, of which the most important is that on the 22nd of January, the vaccine was registered in terms of Section 15, which of course would impact in this matter. And this came to the applicant's knowledge already on the 24th of February 2022. On the 20th of April 2022, the applicants then file a rejoinder affidavit setting out new evidence. And it's strike law that if they want to file such a further sets of affidavits, they need the leave of the court to do so. A further supplementary affidavit is filed this morning, once again not seeking the leave of the court for it to be made part and parcel of the papers, and consequently, because it was done so late and not timeously, the respondents have no time to consider their position or file an answer or whatever they would want to take to such further affidavit. An amendment of the notice of motion is also filed. It's common cause between the parties that it does not adhere to Rule 28.2. It simply does not afford the respondents a time frame with which they can object or whatever stance they want to take. The third respondent objects to the amendment, and the first and second respondents file a Rule 33A notice. This morning, an application for the amendment to be heard or then decided is filed. From all these common cause facts, it is clear that the matter is not ripe for hearing. I want to state that especially where this matter can be categorized, if it can be, as a matter of national importance, the Audi Alterum Partem rule begs adherence, and not that it's negated just because it is urgent. An urgent matter of this magnitude and importance is as a rule managed by the Deputy Judge President of a division. This was in fact done. The directives that the Deputy Judge President issues must be adhered to. If new facts arise, which plausibly can happen, and requires further affidavits to be filed, then the rules kick into place, and they must be adhered to. The only deviation with an urgent matter is the abridgment of periods. In other words, if normally you were allowed 10 days, you can perhaps in the circumstances argue that 5 days, because of the urgency, would be reasonable. But not setting out any time periods is simply bad in law. I refer to the well-known matters of Republikeinse publikasies Edensbeperk versus Afrikaans pers publikasies Edensbeperk 1972-1 SA 773A at 782A to G, as well as Luna Meubelvervaardigers Edensbeperk versus Makin, trading as Makin's Furniture Manufacturers 1977-4 SA 135W at 137, as well as Sikwa versus SA Mutual and Fire and General Insurance Company Limited 1977-3 SA 438W at 440G to 441A. I want to venture by saying that, in fact, the respondents in this matter must be, I don't want to say applauded, but by not objecting to the postponement, which in fact they could do because it's not filed timeously. The reasons for the delay is not before the court. There's no substantive application for postponement. And in fact, as I've placed on record, the applicants had to be nudged into exercising its discretion to apply for a postponement. By not objecting to the postponement, they have in fact acted in the interests of justice. The only recourse they are seeking is that the costs must be paid on a punitive scale, and the reason for that is that the court must show its displeasure with the way or the process that the applicants in this matter are following. The applicants in this matter clearly will have to change their stance in that because the matter is so important and it's urgent, it does not mean that they do not have to adhere to rules. And it seems to be their practice, because I agree with counsel for the first respondent, that sending a letter to them, setting out, well, we find a rejoinder affidavit and you must now seek a postponement, instead of saying, will you please accept this affidavit, shows either a lack of insight or a fact that because it's urgent, the matter must just proceed on the basis that all their documents must be accepted. The fact that a matter is urgent, as I've already stated, does not mean that the audi alteram partem rule does not have to be adhered to, and that the rules of court disappear. It's trite that the court can deviate from court rules, but it has been stated over and over, and again in the matter of the South African Airways, SOC versus BDFM Publishers Pty Limited, where my brother Sutherland expressed strong views of the fact that procedure must be followed in urgence, and that the principle of audi alteram partem is sacrosanct in the South African legal system. The question then that I have to decide is whether the costs which the applicant have offered on a party and party basis must be on a punitive basis. I've decided not to grant a punitive cost order, and the reason for this is that by offering the costs and not relying on the BioWatch principle or making an argument about it, it's not to say that they can't still do it at the application stage, but they will be hard-pressed to do so where they've offered costs in this instance. And therefore, they are at risk. If the application should be dismissed, I don't know whether it would be dismissed or granted, but that they would be held responsible to foot the bill of the respondents and possibly the admitted amicus. I accordingly make the following order. The application is postponed sine die. All the interlocutory applications that are on the papers at the moment and need to be finalized, even if they can't be categorized as interlocutory, but they mostly are to be disposed of before this matter is enrolled again. The parties may approach the Deputy Judge President for a preferential trial or preferential hearing date, and the parties may allude to the fact that I'd read the papers, and they may say, ask the Deputy Judge President that I preside in the matter, but this order is in no way binding on the Deputy Judge President. The costs for Section 27 is reserved. Thank you. The court will adjourn.
Pleases, my lady.
As the court pleases.
She made an order.
Pleases.
Did you say costs?
As the court pleases, my lady.
Let me just quickly get on if I can get onto the screen.
She didn't. You are. It's fine. Put the camera on. I think you should speak before everybody goes.
Sorry, I just, if it's possible, if the registrar is still on.
I'm still on as well.
I'm concerned, sorry, my lady, I'm concerned that we have the reasons for your order, but we don't have an order stipulating that the costs of the postponement will be paid by the applicants. So in the case of the first to third respondents.
I apologize, you did right. I didn't read out the last order. You are right. I apologize. So there's reasons, but not the final order is that the applicants are to carry the costs of today of the first, second and third respondents.
Could we ask for a stipulation in respect of the first and second respondents that such costs would include the costs of 3 counsel, one of whom is senior counsel?
Yes, I'll add that for the sake of the taxing master. It includes the cost of 3 counsel, of which 1 counsel is senior counsel.
Thank you, my lady.
Thank you very much for drawing my attention to that. I don't know why I didn't read it. Thank you.
Thank you, my lady.
Anything else? Okay, thank you. The court will adjourn.